All right, everybody. Thanks for joining. Jess, I think you're going to kick us off here, right?
Yes. Hi, everybody. Um, so today I wanted to talk to you guys about our property management company. Not sure if everybody is aware, but KW has a in-house property manager. And this is a great way for you guys to be one step ahead of the game with your clients to better serve them, especially if you're working with a lot of investors. You can definitely use this as leverage. And anybody that you refer to our property management company, we're giving a $50 referral to. So just a little overview of our services. So we're a full service property manager. We have a little over 900 units right now all over Cleveland, primarily Cuyahoga County. And we pretty much can do just about everything that your client would need us to do. So everything from leasing to maintenance, project management, like small repair items like new flooring, painting. We have connections to plumbers and pest control, anything that your client needs. We have the resources. We can even handle paying bills for your clients if that's what they would like us to do for utilities. So we're full service, and we can be as hands-on or as hands-off as your client would want us to be. Um, Before I go into opening up for questions or anything, I did want to talk through a hot topic that's been coming up a lot in the Cleveland area these days, and that is the lead-based paint coalition that the city of Cleveland rolled out. So the lead safe program, basically, it's a good program, and it's trying to help the kids of Cleveland who are getting affected by living in homes that have lead. So the goal of the city was to try to abate any lead that might be existing in some of these older Cleveland homes. How they decided to do that was to target investors, so people who own the property and rent them. Um, so essentially the way that they're enforcing the program right now is through evictions. So if you have a property that is within the city of Cleveland, um, you cannot proceed with your eviction until you get a lead paint test done. So what that means is you need to get the home tested. The tester has to be, excuse me, a qualified tester through the city of Cleveland. And they will go through the home, they will do the test, and then they will let you know if there's a pass or a fail, or if anything needs to be done. Some of the things that they might recommend doing are window replacements or scraping and painting, windows, door frames that are peeling, decks, ceilings that might have chipping paint. Our team has been helping to do some of those items. If the test does come back and there is like painting that needs to get done, we've been helping our clients with that. We also have a few trusted lead vendors that we have been using that give us discounted rates for the lead testing. You're looking at anywhere from probably 250 to 600 per unit for just the test. That's not including the abatement. And because of this program, a lot of the lead testers are raising their prices, as you can imagine, because of all the demand that they've been getting. They know they're a hot commodity right now. So our vendors are giving us a good price, and we know that they'll do a good job. The testing will be good, and they can also do the abatement work if there is abatement that's needed. So we are helping our clients with and navigating through this program. We're working really closely with our attorneys, which is an advantage to our clients. So we can guide them as to what needs to happen, what happens if they don't get their home tested for lead, what could potentially happen in the future. For example, I am foreseeing that the city will enforce this through the sales. And Jade might actually be able to give some insight on that today, on if she's heard any rumblings of the city of Cleveland making this through their point of sale in order to transfer title. But that's what I'm foreseeing, at least from my experience and on my end. They also are keeping track through rental registrations. So we help our clients make sure that their property is registered as a rental in any city that they own a property in, so they don't get fined if they were to get caught that they're renting the property out. And we foresee that when the renewal time comes for that, that the city will probably use that as a guide to approach properties who have not been tested for lead. And you, per our attorneys, you're subject to fines, violations, even misdemeanor if you do not do the lead testing. So this is just another service that we provide. We try to keep all of our clients up to date on what's going on in the market, what's going on in Cleveland. As you know, most of our clients are out of state investors who are buying properties in Cleveland. So we're really here as a helping hand. So with that, I wanted to open it up for questions. If anybody has questions about our management service, any questions about lead paint, or just any questions in general. All right. Well, I am definitely wrapped up a little earlier than expected. Jade, have you heard anything on your end about the lead paint?
Sorry, I was on mute. I have not heard anything about that, but I know that when we do it, is this just the city of Cleveland when we're talking about, not like, the
Yeah.
Cleveland Heights or anything like that? We do
Yep.
have to do when in any order is opened in Cleveland, we do have to get a city disclosure. And I believe the lead-based paint is on that. I could absolutely make sure of that and kind of look over it again, but I'm pretty sure in order to transfer, we do have to have a lead-based paint disclosure in there.
Right. Right. But the city's not enforcing the home to actually have the lead tested through their application process yet. But working closely with our attorneys, we're foreseeing that they might add that to like their point of sale.
Yeah, I
In
don't think
order
it's
to,
happened yet though. So I'll double check
yeah,
with Tiffany exactly, but I do not, I want to say 90% that it has not happened yet.
yeah. One thing that we are recommending to our clients is if they are buying a property, they can negotiate through the sale. Maybe the seller can provide a credit for the testing if they're not willing to do testing. And obviously, you guys know the title company can help, provide an addendum or provide a credit for the testing. So another advantage for you guys, where you're out with your investor clients to talk about this program and to guide them when they're writing their offers to say, hey, we might want to ask them for a credit for the lead testing because they're going to be on the hook for it when they buy the property. And a lot of people are not happy about that when they are buying these properties and all of a sudden they have to get their home tested for lead and their agent didn't tell them about that and they might not have been aware of that. So again, you guys are at an advantage here of getting all this information, and you can definitely set yourself apart from other agents in Cleveland with this knowledge. So please feel free to use me as a resource. If you guys don't have any questions, then I think I'll let Jade take over and I'm going to hop off.
Thanks, Jessica. We appreciate it.
All right. Bye, everybody.
Hi. All right. Hello, everyone. First off, I'm going to introduce myself. My name is Jade Tyszka, and I am the Client Relations Manager over at GM Title. If you do not know, GM Title is the in-house title company at Keller Williams Greater Metropolitan. And I am pretty much, my job from day to day is pretty much just to be a liaison between you and my office. So any deals that are, have a kink in them, or title issues or anything like that, any net sheets you need, anything that you need from the title company, I am here to assist with. But today specifically, we are going to talk about title and entities. Let me share my screen. Here we go. Okay. All right, so what we are really going to be talking about, I'm just going to kind of go over the entities that we're going to be discussing that are common in title. And then from there, I'm going to tell you what we need from each entity and pretty much why title needs this. Everything we'll need will either be coming from your clients or they could be found in our 42-year search, just depending on kind of what the document we need is. So today we are going to be discussing estates, power of attorneys, trusts, LLCs, Inc/corporations, and then bankruptcy, conservatorships, and guardianships. First thing we're going to be discussing is the trust. More than likely, 100%, you guys are going to deal with a seller or buyer who is either selling a property out of their trust or would like to put the property that they're purchasing into the family trust. So with that, with each entity, title needs different documents. So what we need from a trust is the certificate or memorandum of trust. And this would be prepared by an attorney. It's pretty much a 2-page document, and it's going to have everything that we need to send to our underwriters for them to approve it. What we pretty much are looking for is the full name of the trust. So let's say it's John Smith, Family Trust, dated August 14th, 1999. We would need the full name there, which it would state in the memorandum. It would state this trustees, co-trustees, and successor trustees, and any amendment within the trust and when that amendment took place. If a memorandum is not available, or if you guys one was not prepared, again, the memorandum is not going to be prepared with every trust, but if they do have it, it is just the easiest to give us. It's the easiest that our underwriters will approve it. It has the least wording, and pretty much everything that we need is in that 2-page document. But if they don't have it, we would need a full copy we prefer a full copy of the trust. I understand that some trusts are 300+ pages, so I don't really expect your sellers to go to a scanner and scan all 300 pages. So in that instance, would a full trust be preferred? Absolutely. But in the instance that it just cannot be, delivered that way, we would need a couple sections of that trust. It would be the first page of the trust, which once again states the full name, the trustee's power section, and this is going to kind of outline what powers the trustee has within the trust. So are they able to sell real property? Is there going to be additional signatures required from the co-trustee? Is it just, for childcare purposes? We're looking for pretty much a section that states the stuff about real property. But we do need that power section. We need this section appointing the co-trustees or successor trustees. So anybody that needs to sign along with you, we would need that. And let's say for some reason your buyers or sellers aren't able to sign themselves, we would need to appoint the successor trustee to sign these trust documents. And last but not least, which is often honestly the most missed document that we get, is the last page, which is the signature page. Obviously, this is proving that it is approved by the seller or buyers. This, they read it, they understand it, and this is the way it is. Is there any questions on a trust before we go to the estate section first? Okay, perfect. Next, we are going to talk about estates. So an estate obviously is, let's say a property is not in a trust, it is in an individual name, Joe Smith, and something happens to Joe Smith and he passes away. And because it is in an individual name and not a trust, we would have to open a probate with the courts. Unfortunately, probate can take up to, I've seen it take up to 9 months. So, you know, sometimes I get realtors calling me saying, you know, their dad passed away, the property's in his name, but they're looking to sell it. And I ask, all right, has a probate been opened? And they're like, no, nothing has been opened. And I'm like, ooh, bad news. First, we need to open probate, which can take anywhere from, I've seen it 2 months to 9 months, just depending on, you know, the assets that that person owns. Then once probate is opened and all of these following things right here are approved by the court, then we are able to sell the property. And I'm just going to kind of go over what we are looking for from the probate docs. And by the way, the probate docs for an estate can be found in the search. We do not need anything from your sellers or their heirs. So we can do this ourselves. I'm just going to kind of go over it just for your knowledge. One would be the docket. So just the opening docket, the case number, who the estate is for, and kind of their heirs. The second would be the letter of authority. And this is pretty much saying that everything on there is kind of allowing, it's a page that their heirs have to sign that says that they are able to sell. And it's called a letter of authority. Next is an inventory, and this will name all of their assets along what they are worth, which includes the home. The fourth is a list of heirs. So any children, anything in their will, the next of kin, so to speak. And the last one is the last will and testament. If there is no will and testament, let's say they die unexpectedly, unfortunately of a young age, anything like that, we would also need a consent to sell from the probate court. Is there any questions on an estate? An estate is kind of tricky. Pretty much it's a different case scenario with every single estate. But unfortunately, what I want you to take away with this is estates take a long time to get through probate. So if you have a client who, you know, is selling a family member's home that has passed, the number one question you are going to want to ask them is, has probate been opened with the court? If the answer is no, then say they need to do that before they list anything. If the answer is yes, then we can proceed. Is there any questions with an estate? Okay, perfect. Once again, there is probably a 100% probability that you are also going to be dealing with an LLC. Any property that is in an LLC, an investment property, rental property, anything like that. So for, let's say this is for both buyers and sellers. If there is a lender involved in the deal, we need proof that the LLC is active, and we can find that on the Secretary of State website. We will need an operating agreement for their LLC. This is something that is not found on a website or within a search. This is kind of like a trust. This document would be drafted by an attorney. It would once again outline all of their powers, who the managing members are, who is allowed to sign on behalf of the LLC legally, and, you know, pretty much everything. It's kind of like a handbook for an LLC, rules and regulations of an LLC. Let's say that there is no other members, like there's only one owner of this LLC. We would need what is called a corporate resolution, and that is pretty much just an affidavit stating that there is only one member and they hold all the powers. If your buyers and sellers do not have an operating agreement or a corporate resolution, our attorney who we work for we order all of our deeds for, he can also prepare one. It will just be an extra fee, but just another helpful thing that we do that, we can get that signed at closing. If a buyer is buying cash and would like to put it in an LLC, we would just need proof that that LLC is active in the state of Ohio. Is there any questions on any of that? Once again, LLC is kind of also a case-by-case basis. I've seen a lot of different, people sign, a lot of different corporations, and it's just, once again, it's kind of a case-by-case basis. There isn't just one rule for all LLCs. Is there any questions on that? And this, I just took a screenshot. This is what you will come up on the business search of Ohio. It is what we use to check active statuses for an LLC. So just kind of another asset. If you are taking a listing, it is always good before they sign that contract that the LLC is actually active. So there is no liability there. Once again, title could do this. It's not something you have to do, but if you choose to do so, this is where you would go to do it. This is kind of also, again, just a screenshot of what it looks like when you do search something. And I just wanted to point out the active status on it where you could find that on this document. All right, a corporation pretty much is a different form of an LLC. However, pretty much the same rules apply. We need to make sure it's active. We need an operating agreement if there's more than one member. If it's a sole member, then we would need a resolution. Once again, if your buyers and sellers do not have this, one could be prepared just at an extra cost. All right, and last, or actually not last, but now we are going to move on to power of attorneys. Is there any questions about LLCs or corporations? Okay. All right, so if a seller needs to use a power of attorney, make sure it is the most recent power of attorney because they do get changed. Pretty much every single time you use them, there is an amendment to one. So we do need the most recent power of attorney. Once again, we need it fully executed and signed. You will not believe how many people send us these and nothing is signed on them, which makes them not legal. And C, this is kind of a tricky one. With power of attorney, there is a lot of additional risk that title takes. So underwriting really needs a reason, a good reason why a power of attorney is being used. If your seller is using a power of attorney and it is kind of a sensitive subject, please let us know that ahead of time. Let's say, an accident happened or something along those lines. I can't tell you how uncomfortable it is to call and ask, and all of a sudden someone is bawling on the phone and it's just not a good situation. So if you're ever dealing with a sensitive subject, please let title know so we could take account into that. If a buyer is using a power of attorney, if they are using a lender, first and foremost, it has to be approved by that lender. The lender says no, then we cannot approve it either. And all the other requirements that are with the seller. Are there any questions about power of attorneys? And last but not least, conservationships and guardianships. Kind of like an estate, we would need the court docket, which we could find in the 42-year search, court order, and the court approval of a sale, which again, all of these can be found in the search. It is just, just wanted to let you know for your knowledge. And that is it as far as I have for entities. Once again, you guys, this is just kind of a general overview. With title, unfortunately, every deal is a case-by-case basis, and what might have worked for one deal will not necessarily work for another just because of a certain clause that are in these documents. So it's just kind of a general, you know, guide, so to speak. But I am going to put my information in the chat box. And if you guys need anything, if you want to do another class on maybe generating net sheets or, you know, kind of our process with title, if you're not familiar with it, please reach out to me. I do have a title background, so I do understand title. I did processing for about 4 years for another company. And so once again, if you guys have any questions, need anything on any of your deals, I am here after hours, weekends. I'm going to throw my cell phone in there. Please do not hesitate to reach out to me. Do I have any questions for anything overall in general?
Jade, I do have one question, and this is something that I'm doing now that I'll be writing up. When a seller agrees to give the buyer money for something that wasn't completed during the transaction, what type of wording is needed to kind of be held in escrow? I think that's what normally the money goes to escrow. Does that buyer get cash, or can they use it toward like the closing costs, or how does that work?
Okay, absolutely. I just, by the way, I just threw my information in the chat. So if you guys need anything, don't hesitate to reach out, but good question. Are you just kind of looking for verbiage in your addendum, so to speak?
Yeah, just to make
Okay.
sure I write it correctly.
Yeah, absolutely. Can I ask you what this is? Is it for like a point of sale, holding money for a point of sale or something?
So no, they just didn't want to make one of the repairs, and they agreed to $2,000 toward the repair, just not the full.
Okay.
So they were gonna.
Yeah, I would just say $2,000 is to be held in escrow for repairs, you know, given to the buyer at closing, but it would probably just be a credit taken out of their closing costs.
That's
it would
what I
even
kind of
out in the
figured.
end, but it would just be a credit taken out.
Okay, so it's not
just
like they're giving cash, because I kind of explained it to them too. I just wanted to make sure I said that right. I said, you know, if you have 5,000 in closing costs, that 2,000 will already be there. So then you're kind of just coming out of pocket for 3,000. So
yes, exactly.
Okay, perfect.
Okay. Any other questions? All right. Well, you guys have been great. And like I said, we wrapped this one up early. If you guys could think of anything, I know it's kind of a short thing. So, you know, if you're driving and something pops in your head and you're like, shoot, I really wished I would have asked that. Once again, don't hesitate to reach out. I'm here for you guys. Utilize me. I'm here to help you. Okay.
Okay, thank you.
All right, guys. Have a good one. Take care.
You too. Bye-bye.
Bye-bye.